So good afternoon and good morning to everyone, depending on your location. Welcome to this virtual event called with Dr. Oumar of Cornell University. He will be presenting some of the key arguments and findings from his book, States of Justice, The Politics of the International Criminal Court. So my name is Salvador Santino Regilme. I'm from the Institute for History at Leiden University. Perhaps many of you might be coming from the MA International Relations program or from the BA International Studies. So for today, Dr. Oumar will present his book. And let me introduce you first to Dr. Oumar. Before that, our speaker will introduce his book for the next 20 to 30 minutes or so. And then the second half of our event will be open for discussion. So I think there's enough time for us to engage with each other and discuss Dr. Oumar's book, which is actually widely available. It's available at Leiden University on digital access, which was also sent around during the announcement. I mean, the link for that book. So Dr. Oumar is an assistant professor of international relations in the Department of Government at Cornell University in the United States. His primary research agenda focuses on international criminal justice norms and regimes and the global governance of atrocity crimes. He also studies world making and visions for and alternatives to the current international order from Global South perspectives. He is the author of the book, which will be the subject of today's event, States of Justice, The Politics of the International Criminal Court, which was recently published, published last year by Cambridge University Press. And he has published widely in many leading scholarly journals, such as Human Rights Quarterly, Cambridge Review of International Affairs, African Studies Review, Journal of Narrative Politics, Africa Today, and Africa Journal of International Criminal Justice. So Dr. Oumar also engaged. So when I read his book, States of Justice, also did a lot of field work, even I think in The Hague, as was mentioned in the book. And Dr. Oumar is not new to Leiden. In fact, he was here in The Hague or the Hague campus 2 years ago, where I actually met him in person. He presented a paper during this human rights conference in The Hague. And I can only say that I really look forward to this presentation. I enjoyed reading the book. And for the listeners here, we are recording the entire proceedings. So I'll also, with the speaker's approval, the recording will be shared to the students of MA in International Relations and BA in International Studies. So without further ado, I'll give Dr. Oumar the opportunity to start with this presentation.
Thank you, Santino. It's great to be back in Leiden, although virtually this time. It seems like it was so long ago when we were together there before the pandemic. So thanks for the invitation again. And thanks also to Tina with helping organize this event. And thank you all for being here in this Friday afternoon, evening. I will just make some brief comments so as to allow enough time for us to engage in a discussion and questions and answers, because there is so much to talk and discuss about the politics of the ICC, including some major news that came out of the prosecutor's office even this week. My disclaimer before I go further is that I'm not a lawyer, I'm not a legal scholar. I am a political scientist. I study international relations, so I focus on the International Criminal Court as an actor in international politics, or even a political actor, if you will, even though some will resist that characterization. So my main interest is to look at the politics of the ICC and the politics of the international criminal justice system broadly, from an IR perspective, but not necessarily seeped deeply into the technicalities of the law. So that's one disclaimer out of the way. The main arguments that I've been making over the past few years are that international criminal law and international criminal justice are inherently political. It seems to me that when we look at what the ICC has done so far over the past 2 decades, then we would notice that the ICC seems to be able to deliver justice only on behalf of states. The ICC has been quite effective in securing convictions. At least we could say that the Office of the Prosecutor have been successful in securing convictions when it comes to rebel leaders, opposition leaders, one jihadist, all people who could be characterized as enemies of the states. Yet the Office of the Prosecutor has been struggling in securing convictions for state actors, whether personnel who are part of the state's armed forces or officials in governments. So this is what I call state-oriented judicial mechanism, which is what the ICC has been showing so far. Now the question becomes, how does this state-oriented judicial mechanism square with the ending impunity mantra that the ICC keeps drumming up, and the narrative of we are doing this for victims, we are delivering justice to victims, when in reality, the justice that has been delivered seems to favor states and working closely with states actually to investigate and prosecute those who were deemed to be enemies of the state. The broader argument is that international courts operate in a world made primarily of states. Again, this is where I wear my political science hat. That the international system is made primarily of states. And as such, these states are able to leverage their stateness. And through this leverage, they can instrumentalize international courts. They can use this leverage in pursuit of their political and security interests. And the ICC hasn't been able to escape that instrumentalization. That may seem to be a bit obvious to say. Of course, states that have power would use international courts to pursue their own narrow interest. But I focus here on states that do not wield the global power. I'm not focusing in this book on the United States, for instance, or the UK. I'm focusing on states that are not viewed as being powerful in the international system, so African states. And I find that even African states are able to actually use the ICC strategically in pursuit of their political and security interests. How do these states engage with this court? I come to the conclusion that African states are able to instrumentalize the ICC and use it for their own political and security interests by looking at the ways in which they use self-referrals, meaning that asking the ICC prosecutor to come, inviting the prosecutor to come and investigate situations within their territory, which is a strategic use of the state referral mechanism that was in the Rome Statute, but they're using it in a way that they're not actually referring a third-party state, they're referring themselves. But even that, even using the word self-referral is a bit misleading because they're not even asking the ICC to come and investigate the state. They're asking the ICC to come and investigate the rebel leaders or the commanders or the political opposition in their territory. The second theme I look at is the complementarity principle. Meaning how do national jurisdictions and the ICC jurisdiction overlap? And I find that these states, again, these states that do not wield global power, are able to use the complementarity mechanism and use the ICC as a bad bank, basically, where you would outsource your toxic assets. So inviting the court to come in, get involved in cases that would be too complicated for them to prosecute domestically. The third theme I focus on is state compliance. So if you are a state party to the ICC, then you are bound to comply with the Rome Statute provisions. But state compliance here, even for ICC member states, is a dynamic process. It's like a pull and push between the court and the states that are concerned here. Depending on the political risk of the state leaders or the state agents, then these states would either comply or refuse to comply, basing those decisions on the political risk that the ICC may pose to the elites. And as long as the prosecution is focusing on the enemies of the state, then we do expect these states to comply, and beyond the complying, to even cooperate with the office of the prosecutor. And the fourth and final theme I look at is how the ICC becomes a stage of domestic political disputes, where states that even facing a post-electoral crisis would try to outsource those political issues to the Hague and have the ICC become involved. So ultimately, I contend that African states have been able to instrumentally and strategically use the ICC to their advantage. One contribution of this argument is that this goes beyond the narrative that African states are victims of the International Criminal Court and the International Criminal Justice System. It does not negate that narrative. Of course, there is a whole history of international law which comes out of the colonial encounters, and the foundation of international itself is built upon exonerating the Western states and the Western agents from criminality, whereas punishing and disciplining the global South agents and citizens. So it does not deny that, but it just adds a layer of complexity of how even states from the global South are actually able to strategically use the ICC for their political and the security interest. Now, why would that be a problem? Well, it is a problem insofar as the ICC and the International Criminal Justice System are still in denial about the political dimension of the project itself and the possibility of it being instrumentalized by state actors. This denial is based on the long-held attempt of the International Criminal Justice Project to divorce itself from politics. Whereas politics are viewed as tricky, dirty, quote unquote, beneath law, which is supposed to be of a higher level of abstraction and of a higher morality. So there's an anxiety for these courts to be associated with politics and to be viewed as being used as mere tools in the hands of political leaders with political agendas. The other contribution of this is that it provides a critique to the justice cascade argument. For over 2 decades, we have been hearing and reading a lot about this justice cascade argument that there is now a move towards personal accountability and atrocity crimes ought to be punished, and the world is moving towards this goal of ending impunity for these kind of crimes. There's no more blanket amnesties that are acceptable, etc. My argument does provide a bit of a critique of this justice cascade argument to say, wait a second, yes, now there is an international criminal court that did not exist 25 years ago. Now you do have a lot of ad hoc courts, you have commissions of inquiry, you have all these mechanisms that are supposed to bring accountability in the face of atrocity crimes. But a lot of these mechanisms are still put in place and used in ways that do not necessarily mean that these actors have bought into the norms of accountability. So the normative power of this justice cascade is not, in my opinion, as strong as we previously believed, because ultimately, even the states that pretend to have been socialized into these norms are being very strategic in how they either use the norms, resist to them, or pervert the norms. And this perversion means basically using these norms in ways that were not anticipated before, creatively instrumentalizing this. The use of self-referrals, for instance, would be one such example. So the argument is also that it's not that the ICC has become instrumentalized. It is that the ICC was an instrument even from the beginning. The ICC was a tool to be used for purposes, and a political tool also, because it is not that the ICC has become politicized. It is that it was political from the beginning. Why? Because it was created by states, and you cannot be more political than states. The ICC does have a link with the UN Security Council, which can either refer situations to the ICC or defer them. And the UN Security Council is the highest political body that is. The Rome Statute was negotiated by states who had different interests, who wanted different things, and it became a document of compromise. So in many ways, you can view it as a treaty. So it's a legal document, but also this is a political document which was negotiated and put together by political actors. But the focus on norms and institutions of international justice, the focus on the legal aspects and the normative force of these courts and commissions of inquiry and fact-finding missions and prosecutions and trials, they obscure the problematic foundations of the international criminal justice project and how it is deployed and wielded, both at the international and local level, both by powerful and less powerful states. But the ICC refuses to see politics. It refuses to see race also, but that's a discussion for another day. And this refusal to be able to see politics and this mantra that we are beyond politics, so we do not take into consideration political calculation in the work we do because of the anxiety of being viewed as not legitimate, is compensated by this focus on the victims. So there's this reification of the victim that is the raison d'etre of the court. You hear officials of the court will just say, they will always repeat that we are doing this for the victim. We are focusing on the victims, and this is justice for the victims. And this is where the legitimacy comes out of. But this focus of the victims also is linked to a narrative of reification, where the criminal justice system becomes reified in international politics as the appropriate venue to deal with all these questions of mass atrocities, of massive violence, of justice. So justice is become narrowed and boxed into this reified system of international criminal justice, where the ICC sits at the top. And despite the shortcomings of the ICC, despite the problematic origins of the ICC, despite the problematic foundations of international criminal justice, the ICC is viewed, even when it fails, it is viewed as an institution that is failing on its way to success. It is, even despite all its shortcomings, it's viewed as this institution that is changing the world just by existing, despite its many faults. So Prosecutor Bensouda said, for instance, I quote, "Without the ICC, we will regress into an even more turbulent world where chaos, volatility, and violence take the upper hand as an inevitable norms." So the only thing that is separating us from a chaotic world of barbarity is the existence of the ICC. This is the perspective that we're hearing from ICC officials. So this is also part of the master narrative of progress from Nuremberg to The Hague. So there's this march towards an enlightened world of justice where mass atrocities will be punished. And this master narrative of progress, which results in a reification of international criminal justice and of the ICC, makes us unable, or at least not critical enough, to see how much the ICC is failing, or to see how much problems the ICC is not able to solve, despite the faith that we place in the institution. That also prevents us from rethinking the fundamental role of criminal trials and their usefulness within the Hague justice system. There was a review of the ICC that was put together by some experts, I think last year or the year before, that tries to figure out, the crisis of the ICC and what path forward. And the interesting thing is that, this review was like 348 pages and had dozens of recommendations. But it focuses on the ICC as an institution. It talks about the bureaucratic culture of the ICC, for instance. But there are some broader questions that are left unaddressed, these political questions that I mentioned earlier. The question of race and racism is not included in the report. The word race does not appear anywhere in the 348 pages of the report. Yet, how can you look at the ICC, look at international criminal justice, and avoid the elephant in the room, which is the question of race, actually? So these questions must go beyond just trying to fix the ICC and look at the broader questions of what sustains the international justice project, it's the foundations on international law, it's a foundation on Western liberalism and Western version of humanity, quote unquote, but also the imperialist origins of this system. And this is not just about the origins of the system, this is also about the daily practices of the system, which are still in many ways imperialistic. And as long as that we will keep viewing the ICC as central to humanity's progress, it will still be a challenge. It will be difficult for us to notice the extent to which the project itself is deeply flawed. I will stop there and happy to engage in a discussion or clarifications. Thank you so much for your attention.
Thank you so much, Dr. Oumar Ba, for a very clear and compelling presentation of the book. I just wanted to say very briefly that when I read the book, it's, aside from the compelling argumentation, it was also clearly written. And when I heard you speaking too, it made it, it's as clear as the way that it was written. So I think it's I would say it's quite rare in our profession to have writers who write clearly, as what I read in States of Justice. I'll reserve my questions later. I'd like to give opportunities to our viewers here, or even Tina, our student assistant, for questions or reactions. Tina.
Yeah, thank you so much. And thank you so much, Dr. Paul, for your clear and really interesting presentation and on the subject. So the thing that I was thinking for the whole viewing of the presentation was that how is the role of International Criminal Court will change if we see a change in US hegemony and a move to Chinese hegemony later on, as it's really a hot topic these days. So will it be a change in that regard, or it will still be the ICC be a tool for the Western liberalism hegemony? How do you view that?
Thanks, Tina. That's a great question. I actually never thought of it this way. You're right that, both the US and China are not ICC members at this time. And I do not think any of them will join the ICC anytime soon. Also, both are members of the Security Council, as you know well, and meaning that they do have some leverage over the ICC. As Security Council member, they can refer all different cases or situations to the ICC. Now, there is also a fundamental difference between the two countries, between the US and China when it comes to the ICC. One difference is that the US is engaged in a lot of military operations around the world, which means that US soldiers are likely to, or at least likelier to commit crimes that would fall under ICC's jurisdiction eventually than Chinese personnel, because we do not see Chinese personnel, military personnel engaged in wars or using drones and bombing places around the world. So that's That's a difference there. Now, what does it mean in terms of how they would both engage with the ICC, or how that would change if we would move towards a world of Chinese hegemony compared to the US one? It's hard to predict what Chinese hegemony will look like. Will China engage in military operations around the world as the US is doing right now? I do not know whether that will be the case or not. But if that is the case, then that means that China could also become part of the deliberation and discussion of the ICC. In any case, even though there's been accusations of US personnel, both military and the CIA, of having committed crimes, even the ICC has found that there is enough evidence during the preliminary examination with the situation in Afghanistan. What we've noticed is that the ICC is actually willing to go the extra mile not to upset the United States. So if we were to be in a different world order where we would have a Chinese hegemony, my prediction would be that even in that situation, the ICC would also, because I think it's a survival depends on that, on not upsetting the great powers, and they're pretty much aware of that. So even in that situation, the ICC probably would try to accommodate the interests of the most powerful states. They will, I mean, the ICC, of course, would deny doing that. They would just say, well, we just follow the Rome Statute wherever the evidence leads us, but that's not a credible argument, I think.
Thank you so much.
How about the others? Or Tina, perhaps you have another set of questions, or the others, Ludovica, I think, Ming Yu and Lara. I have a question, a set of very brief reactions. I think the book is really a powerful intervention in so many ways in various literatures. But what I find very compelling, at least that resonates me the most, is the idea that you underscore the political agency of global South actors in global governance, particularly in the international justice system. And perhaps it resonates me well because my own work on foreign aid dispels this extreme arguments by, for example, saying that foreign aid is totally imperialistic to the extent that global South elites are just passive agents, or global South actors are passive agents. It also dispels the other argument that it's extremely good. So I find the empirical explanation for ICC very compelling. I wonder I was wondering about your views on the Justice Cascade movement, because you mentioned about the narrative of progress. I was thinking, if, for example, don't you think that there's also an emancipatory potential for global South civil society actors, or perhaps opposition movements in the global South states, perhaps even beyond Africa? Because I'm familiar with the case of the Philippines. They rally to the ICC, and they, in fact, invest on this narrative of progress in the hope of delegitimizing a despotic regime back home. So I was wondering, what is your view on this? Because when I read the conclusion, which is indeed very insightful, there's the last paragraph leads to this idea of the local forms of justice. And I think this could be part of your many projects in the future. But I was wondering, like, in the case of the Philippines, many opposition actors are hoping that, and they do instrumentalize the ICC for their aims, but they're hoping that this sense of narrative of progress is a useful fiction. So I wanted to hear your views about this.
Yeah, that's a very well put. Useful fiction. or maybe even a hopeful fiction. That's an interesting way of putting it. And it does connect to, as you said, in the conclusion, I asked you this question, whether the future of international justice is local. And I would think, yes, we would see more localized forms of justice, because they tend to be more effective. They tend to be closer to the local context. They can tend to speak broader to the actual people's demands on the ground. So even if you take the case of northern Uganda, of the LRA, you go and talk to these people who were victimized by the LRA, you ask them their views about the Hague's justice. And even in those instances, they do tell you that we would have preferred, for instance, that Dominic Ongwen be brought and tried here locally, or we would have preferred that he be brought and go through some traditional rituals of cleansing and everything. So maybe confess to what he's done, because after all, he's our son, and then see whether there should be trial, Western version of trial, or trial in the Hague and stuff. So again, the future of international justice is quite local, probably. But also to the question of the agency of global South actors. And here I'm not just talking about the states, but civil society, local NGOs and citizens and social movements in the global South. They have never been silent regarding the kind of international justice system they want to see. They do have specific needs and some version of an outlook of international justice institution that they want to see come live. For instance, during the Rome negotiation, even prior to the Rome negotiation, when the idea of creating the ICC was being debated at the International Law Commission, you had these representatives from African states. I'm sure it's broader than African states, but my focus here was on what were African states and delegates saying. What kind of court did they want to see come out of The Hague? And if you go back to those archives, you will see that they did want a court that would be independent from the influence of great powers. That was one of their main concerns, making sure that the prosecutor would not be under the influence of great powers, making sure there is a total disconnect between the court and the Security Council. But beyond the institutional design, they wanted also a longer list of crimes over which the court would have jurisdiction, because those crimes spoke to their experiences. They wanted colonialism to be one of the core crimes. They wanted the use of mercenaries to be a crime. They wanted international drug trafficking to be a core crime. They wanted willful destruction of the environment to be a core crime. And of course, those were not included in the Rome Statute because the Western states didn't want that. And there was, I mean, the archives have all these debates. And when the African states decided to create their own mini version of an ICC, when they decided to create the African Court of Justice, and they amended the protocol, the Malabo Protocol, interestingly, they included those crimes in the Malabo Protocol. So the African Court of Justice is not operational yet. The Malabo Protocol doesn't have the ratifications needed yet. But if it were to become operational, its founding document has all those crimes that African states were concerned with from the beginning included there. Of course, there are some problems too. For instance, they decided that heads of states will have immunity, so that's self-serving, of course. So nothing, it's not perfect to that, to what they're trying to do. But in any case, you can just see how global South actors, like the example you gave with the Philippines, have always been active in trying to build these institutions, not just locally, but even international institutions that will speak to their specific needs and aspirations. But sometimes they do not succeed into having their voices heard in the institutions designed the way they would have preferred.
Thank you. And perhaps there are others who'd like to ask some questions or comments, reactions. Tina, I can see your face of curiosity. Go ahead,
Yeah,
please.
yeah, because I was thinking that because I'm really concerned about the Middle East and Middle East issues, and what I have seen, because there is a lot of war going on there, from Afghanistan to Palestine, and uh, what I have felt, and I'm really not expert on this issue, but is that the Western hegemony in the Middle East has shifted from a more of a colonial direct influence to a more of a proxy influence or influence through others. So although that they are not part of ICC, um, their agents also will not be prosecuted in the court. So it's like that that part of the world that at least I know of is not going to be prosecuted in any sense in ICC, and the agency is just vanished because of, I don't know, economic interests, mainly economic interests, and consequently they really don't care about civil society and opposition there, so they are being repressed. So it's not like that there's no way out of this crisis, or international justice is not willing to intervene because of all these issues, and they're advocating so much for this hegemony and these other actors. So and it doesn't seem to get any better, specifically after this incident in Afghanistan, and how the Chinese supported, the Americans supported, even Middle Eastern states didn't do anything. So yeah, that was my concern about how this is going on, because we can see that the Chinese are trying to, not with military sources but with economic sources, to recolonize Africa and Middle Eastern states. So this is not really hopeful for me.
Yeah, you raise very important questions. Of course, there's a lot of atrocity crimes being committed all over the world, especially in Africa and the Middle East. These crimes are being committed not just by local actors, but also international actors with very sophisticated weapons and military support. And what is the response to this? And this is not just um, about military violence, and as you said, it's also about violence by other means. It's through economic crimes. It's also through imposing sanctions on states, which starves local people, and so it's also violence through the destruction of the environment. Now, what are the responses, or what are ways to address this? What forms of justice would be the most equitable and beyond the forms of justice, I think it's also what is the way outside of these cycles of violence. These, of course, are complex questions, and I have no answers to them. What I've seen is because there's literally a big vacuum in terms of ICC reach in the Middle East. Interestingly enough, actually, there are a lot of Middle Eastern countries who were part of the negotiation to create the ICC. But somewhere along the way, they dropped out, and it would be interesting to see actually what did happen. I've seen in the International Law Commission's deliberations, representatives from Egypt or representatives from Algeria were actually very present there. I don't know what happened there, but now what the international community is trying to do is put in place these ad hoc courts, which have also a lot of problems. I mean, the example of the tribunal for Lebanon, for instance, is they just ran out of money recently and decided to close because the funders were no longer funding them. I think it did cost a whole lot of money. They achieved only one conviction, and the trial was done in absentia. So again, I'm not totally sure these ad hoc courts are a better alternative to the ICC. Currently, the UN does have this mechanism of collecting evidence against ISIS and preserving those evidence materials in the hope maybe of in the future putting in place maybe an ad hoc tribunal. In any case, my hunch is that, as I said earlier, probably the way out of this would be a local solution. It would be ways for these states, the populations, civil society, grassroots movements, social movements, to figure out a way of ending these cycles of violence and abuse and exploitation, both by domestic leaders, but also international actors, and figure out what kind of justice do they want, what kind of justice do they think is better suited for them to close out these cycles, but also bring accountability for the victims.
Thank you so much, Dr. Bob.
Thank you. I think let's go on for, I'd like to ask very briefly and follow up on this idea of a cycle of exploitation and the role of local actors, because I felt that I do think that local actors, their own communities, should really determine their own future. And I think this is really part of self-determination. I wonder if this kind of prospect is conditional depending on the context, because I felt that many problems are interconnected as part of the global order. For example, ranging from neocolonial forms of economic exploitation, that despite the fact that you might have a very powerful and active civil society and social movements in these countries or even regions of a particular country, it might not be enough to topple a very powerful oligarchic set of elites, and therefore some form of transnational coalition building might be needed. Not even talking about the court, but perhaps other civil society movements, but even then it might not be enough. And for some cases, perhaps, I wonder, what do you think? Is that a conditional statement, or do you think that some form of global form of justice might be needed? And if so, what could that look like? Do you think that could only be possible in the case of a global state with radical material distribution of goods amongst communities? I'm sorry, but I was just wondering what your views are about this.
I mean, if we're talking about redistribution, I'm all for redistribution. I mean, I'm for the distribution of wealth and of privilege, and so redistribute everything. I'm all for that. The question, though, I think one of the issues is the broader you want this, like the closer you get to being global, the harder it is to implement. So if you want an international code, it is likely to be less effective than, let's say, having a regional code. I'll give you one example. ECOWAS, this community of West African states, does have a human rights code, which is quite effective. And ECOWAS code has, like any citizen of one of those 16 states can go to the ECOWAS court and file a complaint against your own state, saying, my state has violated my human rights. And ECOWAS has delivered a lot of rulings in favor of the citizens against their own states. But as much as ECOWAS is quite effective, the UN, not the UN, the African Union is quite useless when it comes to human rights because it's at the continental level. So this may not be always the case, but I tend to think that even regional courts tend actually to be, in the human rights regime, tend actually to be quite more effective than international court. Like the European Court of Human Rights is quite effective as well. My earlier argument was that there is a political instrumentalization of these courts. I don't think we can escape that. I think that states are still bound. They still will try to use these systems to their advantage. The question becomes, how much can civil society resist that politicization? How much opposition force can civil society bring to the table against the states and maybe have an upper hand or have small victories? So yes, the local is important. Having local versions of justice, having local institutions, having also regional courts of human rights, and integrating civil societies across the region. So in Southeast Asia, for instance, if you were to have all these social movements and human rights groups working together, supporting one another and building capacity, I think that potentially could be much more effective than having global NGOs, for instance, running the agenda, or international courts trying to bring justice in these places.
Thank you so much, Oumar. So I'll just raise the final set of questions, unless there's anyone else who would like to ask or share the reactions. Okay, because when we share this recording we have students who are doing an Ideas in World Politics course, which is a core course of the MA program. I think this might be a question that might be very relevant for them. So my question to you first is, what sort of advice would you be willing to share to students who are of international relations, who are interested in issues such as global justice and human rights? What kind of advice would you like to share in terms of the future of the field from your perspective? What could be those exciting questions that are perhaps often marginalized in policy discussions and also in our field as scholars, knowing that these students will be the future generation? And second, for my research methods students who are focusing on research methods in human rights, if I may, I'd like to ask, did you encounter some difficulties, challenges, or pleasant surprises when you were conducting the field work as compared when you started with the research? And perhaps you can share some quick tips on conducting human rights research, particularly with this important global institutions such as the ICC.
Okay. Good. Thank you. So for the first question regarding advice for students about the future of the field and how to engage with it, I think as we are thinking about the future of IR, of the study of human rights and institutions, it's important to pay a lot of attention to its history. We can only figure out the current crisis or where the fields are going if we pay enough attention to its history. That's why I think it's important to go back to the archives. Go back to the discussions when these institutions were being put in place. Return to its historiography. And don't just focus also on the official history. Question these dominant narratives about, Western liberalism, the idea of human rights. When people tell you about human rights, ask the question, but who's the human here? How is humanity measured? Who's involved? Who's excluded from these discourses? And of course, this brings us to the critical perspectives of this system. So let's try to resist the reification of the dominant narratives when it comes to both IR and also the study of human rights. Regarding the field work research, there's a tendency in human rights research to focus a lot on data sets, doing quantitative measures, which is good because it does help us with sophisticated tools to get better insights on the field. But at the same time, I want to stress the importance of qualitative research in human rights as well. The importance of doing field work. If you can afford it, if you have the means to do it, if you have the time to do it, go out in the field. Go to the sites where these events occurred, to the sites where these institutions were created. Talk to the people, and that's the importance of interviews. So yes, go to The Hague and talk to the people who work at the ICC. That's very important. But also, if you can go to northern Uganda and talk to the victims of the LRA, that's equally important. It does help you, figure out or find different perspectives. In any case, I think it's important to try to go to these sites, try to talk and interview people. If for logistical reasons you are not able to do that, there is still ways around it. Read the local news from these places. Try to talk to people from there via Zoom, if possible. Or read what they're writing, read alternative histories, read what is being produced by Ugandans or Kenyans or Afghan researchers regarding the states of human rights in Afghanistan or in the war of Afghanistan. I think it helps to always try to broaden our horizon as much as possible. And then you may not use everything you find in your research. You may conduct interviews and some of the transcripts may never end up into your actual book or article for a host of reasons. Sometimes you may even struggle with how do I write about this that I just learned? It may be a challenge, of course, but it will be part of your experience. It will be part of your training. And if you are able to share it with the scholar community, and we all would be better for it.
Thank you so much. Thank you so much, Dr. Oumar Ba, for your very insightful presentation and also for writing a wonderful book that speaks to many audiences, even beyond perhaps its intended audience of IR scholars and legal scholars interested in the ICC. And I hope for those who will be actually viewing this recording later on, so not in its live presentation. So I encourage you to read the book. And for those Leiden University affiliates and students, the book is also available at our library on its digital format. So again, thank you so much, Dr. Oumar Ba of Cornell University, for your time and interest in this virtual event. Stop the